Advocate Ngcukaitobi, we paused when you were cross-examining Advocate Batoi. Let me remind you, Madam, that you are still under oath.
Noted, Chairperson.
You may proceed, Advocate Ngcukaitobi.
Thank you, Madam Chair. We are indebted to the panel. Advocate Batoi, if you recall, when we adjourned on Monday, I was still dealing with the basis for the charge in relation to, I think, Lieutenant General Mdluli. You recall that?
I do.
Now, you will also recall that I had asked a question as to whether or not there was an exclusive reliance on the opinion of Advocate Ngcukaitobi, and your answer was that there was not. You had other material you looked into, correct?
That's correct.
Now, can I just understand, why did you approach Advocate Ngcukaitobi? What was the problem?
There wasn't a problem. It was just that I was wanting to, at that stage, I had looked at the opinions. I had considered the other material that I mentioned yesterday. So I won't, well, the last time we were here, I won't repeat that. I hadn't looked closely at the evidence itself. Advocate Hali and Wenzel were at the Zondo Commission and had an intimate knowledge of the evidence itself. I then asked him for that, for an opinion, together with aspects of the evidence that I could look at. And the purpose of this really was to make sure, as I mentioned, that that if I did refer the matter, that I had taken all the steps that I could have to make sure that I was not getting it wrong.
Now, the evidence you say you had not looked at, what evidence is that?
Those were the attachments to Advocate Hali's and Wenzel's statement, opinion. We can have a look at that. But included in that was the statement of Colonel Rule Officer, who was the investigating officer, that summarized aspects of the evidence in the docket.
Yes. So it is the statement of Colonel Rule Officer. What else?
Maybe we need to go to Advocate Hali's and Wenzel's affidavit just to see what was attached to that.
I think, Council, we can, if you have that legal opinion ready, you can take us to the page.
I think the witness has found it.
Has
I found the affidavit, Chairperson. I don't have the annexures here. I will have to quickly, they're not attached to this affidavit.
in our bundles, it is LO 4.
Well, it's
LO volume 4.
the page.
What page number is it, Chairperson?
1047.
It's 001047. Yes, yes, yes.
Yes.
This one here?
Thank you, Council.
Oh, yeah, right. Chairperson, I am...
Can this lady who's sitting next to you stop giving answers?
Oh, no, she was not giving answers.
No, she's giving an answer. I've heard it. So I'm just cautioning her. Please continue, Advocate.
No,
it's not your fault.
May I ask, Chairperson, what answer did she give?
All right.
Because I didn't hear any answer.
Please, let's not get there. Let us not have that kind of an exchange.
No, Chairperson, the only reason why I'm asking is because this is a record, and I wouldn't want it to be that she's giving me answers, because she's helping me find...
I think it is easy, Council, to simply say she did not give me any answer.
Thank you, Chairperson. She did not give me any answers.
That will be enough.
All right.
Well, whatever you say, Madam, will get into the record. The transcription is very, very sharp. If you need to talk to her, or just to give her document, give her documents, but don't speak because it's going to get into that microphone, whatever you say. Proceed, Council. We have volume 4, LO 001047.
Chairperson, I am there. This is the opinion of Advocate Hali and Wenzel, but it's not the annexures. So if I need to answer that question, unless we have the annexures available somewhere in the bundle, I'll need to quickly look at. I see there's annexures are boldened in the affidavit. Might not be too difficult to go through it quickly. At paragraph 1049, if I may, Chairperson.
You may.
At paragraph 1049, page 1049, paragraph 5, the affidavit of Colonel Rule Officer, who investigated the charges against Lieutenant General Mdluli, was attached marked A.
Yes, thank you. What else?
I don't know, I'm just checking to see what it is. B is a copy of a letter.
So let's just stop there. That letter in B
Mhm.
has nothing to do with the charge against Lieutenant General Mdluli. Is that correct?
And where, for the purpose of the record, where is B, annexure B?
It's
It's
paragraph 20, Chairperson.
It's referenced at LO 001-1057. It is a letter that General Mdluli addressed to President Zuma on the 11th of November 2010. It's referenced at paragraph 19 and 20. What I'm asking you is that letter has nothing to do with the docket against Lieutenant General Mdluli.
It gives context to Lieutenant General Mdluli's representations to Advocate Chauke in that he alleged a conspiracy as well.
I understand.
But for that, nothing further.
Thank you very much. Then let's go to the next document.
I think those were the only annexures.
Yes, thank you very much.
I beg your pardon, at paragraph 27, LO 00
Oh, yes.
1059, paragraph 27, there's annexure C there.
That's correct, Chairperson.
Annexure C is at paragraph 27. Thank you, Madam Chair. But it is a letter by Mr. Mdluli's attorney to Advocate Chauke, which is simply representations.
Oh, there's E, there's D and E as well.
Well, D is at paragraph 31, which again is a letter of the 31st of October 2011, which is an affidavit according to the summary here, which sets out his allegations of a conspiracy. Can you see that?
I do see that.
Yes. Then there is E, which is at paragraph 32, which again references General Mdluli's allegations of a conspiracy. Can you see that?
I do.
And then there is F, which is at paragraph 36 of the opinion, which is a letter from Advocate Chauke to Advocate Van Zyl to ask for a response to the representations by General Mdluli. Can you see that?
I do.
Yes. There is no other annexure referred to there.
I just want to make sure. I thought there were only two. Yeah, it appears there's no other annexes, Chairperson.
Now, therefore, what it means is that all of the annexures, except for the statement from Colonel Rolofse all pertain to the representations that Lieutenant General Mdluli made and the responses given by the NPA. Is that not correct?
I just want to make sure that there are also responses given by the NPA, because I'm not sure about that part.
That is Annex F.
It's not a response. Well, it's a letter from Advocate Chauke requesting Advocate Van Zyl to provide him a report
Indeed.
on the
Yes,
representations.
that's what I'm talking about.
That is correct. It is so.
So the only document there that explains the basis of the charge against Lieutenant General Mdluli is the statement of Colonel Rolofse.
That's correct.
Yes, thank you. Now, I want to come back then to what I was asking you. Advocate Nalane had given you an opinion, correct?
That's correct.
Advocate Moroka SC had not given you an opinion, but had given the Minister of Justice an opinion, correct?
That's correct.
Yes. Despite the opinion of Advocate Nalane, you did not make a referral, correct?
Can you explain that question?
You did not write to the President asking for the Minister of Justice, asking the Minister to ask the President to set up this inquiry.
I did not do it after the opinion of Nalane. That's correct.
Yes, you did so only after the opinion of Advocate Gadhali.
I did so after I got the response from Advocate Chauke in the form of Advocate Maineche's opinion, as well as the opinion of Advocate Hali.
I thought we had covered this ground because I don't want to keep trying to act as if I'm catching you, because your own evidence in chief made it clear that by the time you went to Advocate Hali, you had already asked him to settle a letter.
I did say that, but I hadn't made the final decision.
Which is at paragraph 2 of the opinion by Mr. Hali SC. On 4 July 2023, we settled a draft letter for the NDPP in which she recommends that the state president institute an inquiry in terms of section 12(6)A of the NPA Act into the fitness of Advocate Chauke to hold the office of the DPP.
I had not made a final decision in the matter, but certainly Advocate Nalane had recommended it. And I still wanted to make sure after I spoke to Advocate Hali.
Yes, thank you. Now, you also mentioned that there were gaps in the opinion of Advocate Nalane. Is that correct?
I beg your pardon, Counsel. Now that you referred to paragraph 2 of Advocate Hali's opinion, do we have before us a letter requesting Advocate Hali to prepare an opinion? I just want to follow the date on which that request was made, if any. Are you aware of the letter from Advocate Batoyi requesting Advocate Hali to prepare an opinion? In other words,
no.
A brief or a request?
No, Madam Chair. What we did, I was asking my junior now to remind me. The letter that was asked for is a letter of instruction to Advocate Nalane, which, as I understand, has not been produced yet. This has not been requested, but it's not in the bundles.
May we ascertain from Advocate Batoyi if there was a letter of instruction?
I can't recall.
May I finish, please?
Certainly.
To Advocate Hali, as you did with regard to Advocate Nalane, if there is any such a letter of instruction?
Chairperson, I will have to check the records. What I do recall I spoke to Advocate Hali about it. Whether there was a further brief from the state attorney, we will have to look at, or whether he was already doing work for the NPA in this regard. I'm not sure whether there was, so we'll have to check that. I don't know whether there was a brief specifically for this opinion.
But you say that you had spoken to him, I
That is correct.
suppose, telephonically?
That is correct.
Yes. Thank you, Madam Chair.
May I also make a follow-up on that outstanding letter, the instructions to Advocate Nalani, so that we get all those documents placed before us before we forget? What has to be done now? Because that letter was promised, I think, last week or during the early this week. Have you
Chairperson,
been able to find the letter, the instructing letter to Advocate Nalani?
Chairperson, the team has been looking for this. Perhaps they can assist in giving us an update on whether they have located it.
May we find out from you, Advocate Mutlamanyane, and your team? I suppose that that letter, we can just record that that letter is still outstanding. And please let it be made available to us as undertaken by the evidence leading team.
Madam Chair.
May I please, if you have the letter, I think make it available so that you don't confuse the record. Do you have the letter? The instructing letter? Has it been made available to you?
Madam Chair, I'm informed by Advocate Ngcukaitobi that it formed part of the list of exhibits, and I'm told it is Exhibit 9 in the list of exhibits that were handed up sometime last week.
Yes, I think just to avoid confusing the record, when we adjourn for tea, draw our attention specifically to that document. Make sure that we all have it in front of us. And then secondly, please ascertain whether there was a written communication by Advocate Batoyi to Advocate Ali SC. And let's have those documents.
We'll do that, Madam Chair. Thank you, Madam Chair. Advocate Batoyi, I think we had settled on a position here that there was no decision, whether preliminary or final, on your part, informed by Advocate Nalani, but there was a decision informed by Advocate Hali SC. Is that correct?
There's no final decision. There was no final decision.
I understand.
Until after the opinion of Advocate Hali and Wenzel.
So I understand. So really the point here is that the decisive opinion that convinced you to make the referral was that of Advocate Hali.
Well, it was more let me put it this way. It was looking at all the opinions as well as, in particular, the affidavit of Colonel Rulofsir that summarized the evidence in the docket.
No, I understand that. But that affidavit of Colonel Rulofsir came to your attention only because it was attached to the opinion of Advocate Hali SC.
It did come to my attention in that way.
Yes. Now,
I think for the purpose of the record, I'm sorry to interpose. Yes. We are dealing with the Mdluli matter.
Yes.
My understanding is that the opinion of Advocate Hali was sought only with regard to the Mdluli matter. I just want us to get it right.
Madam Chair, that appears to be so from the summary given by Advocate Hali himself in the opinion.
Meaning, if my understanding is correct, that as regards the Katomena issue, an opinion had already been formed as regards the referral,
Yes.
but then Advocate Batoi needed a further opinion following Dr. Broughton's opinion,
Yes.
which was then clarified according to her. I may not be using her words, but she needed a further opinion, hence the request to Advocate Hali as regards the Mdluli matter.
Yes, Madam Chair. Perhaps we can ask the witness to look at the opinion of Advocate Hali at page 001049, LO 001049, at paragraph 4.
I'm there.
Now, what is stated there by Mr. Hali is that the NDPP is satisfied that Advocate Chauke has committed misconduct in relation to the Katomena matter. She has requested us, however, to provide her with a brief memorandum explaining the process of reasoning regarding the Ramokhibe matter and to provide her with whatever evidence is available to support our process of reasoning. We do so below. So that seems to make it clear that the brief to Mr. Hali was limited to the matter of Lieutenant General Mdluli.
That's correct, Chairperson.
Yes. Now,
Thank you, Council.
Thank you, Madam Chair. Now, the Chair has prefaced the next point on this issue, which is the references to Dr. Broughton. If I could start by asking you to look at the third file. We gave you 3 files. There is a third file that was submitted this morning. And to go to page 130. We've also given file 3 to the panel as well. Oh, I'm told that the Secretariat was waiting for a request to submit them. I apologize. Please do. Yes.
Yes, thank you, Council.
Yes.
That is by order.
Yes. Thank you very much.
Thank you.
If
This will be file 3.
File 3, yes, Madam Chair. Yes. So if I could ask you to go to page 130.
I'm there.
Yes.
And it's a 130 of file 3.
Of file 3, yes, Madam Chair. Yes. Now, there is an extract from your evidence of the 28th of November, 2025, correct?
I see that.
Yes. Now, there you are explaining how you got to Advocate Hali. This is what you say. I was of the view that there were indeed gaps that were identified by Advocate Nalani SC and that all the relevant evidence needed to be thoroughly considered, correct?
I do say that.
In mid-February, I therefore requested Dr. Advocate Broughton, research and legal support and legal advisor in the office of the NDPP, to furnish me with an opinion in this matter. Is that correct?
That's correct.
To such end, I provided Dr. Broughton with Advocate de Kock's memorandum and the opinions of Advocate Nalani SC, Advocates Maineche SC and Scott. On 23rd February 2023, Dr. Broughton provided me with his opinion. He concluded that I should make a recommendation to the president regarding the fitness of Advocate Chauke to hold the office in respect of his involvement with the handling of the Boyson matter. He did not deal with the Mduli matter. Is that correct?
That's correct.
And then you've attached the opinion of Dr. Broughton. And then when we look at your affidavit, I could ask you to look at page, we just took the relevant passages because it's a long affidavit. If you go to page 139, sorry, 138.
I'm there.
So if we start at paragraph 173,
Sorry, I think I'm in the wrong place.
so maybe then,
SB 138, actually. No.
no, it's the same document, file 3.
Oh, it's this.
Yes, we took extracts from your sworn statement.
Okay, so where should I go to?
So page 133 of the same file. Don't move from the file.
Okay.
138.
Okay, I'm there.
So does it start with paragraph 173?
It does.
Yes. So that is the extract from your affidavit. You say here, on 23 February 2023, Dr. Broughton provided me with his opinion. He concluded that I should make a recommendation to the president regarding the fitness of Advocate Chauke to hold office in respect of his involvement with and handling of the Boyson matter. Then you say he did not deal with the Mduli matter, correct?
I do.
Yes. And then you go further at paragraph 176, the same page, where you are again summarizing the second opinion of Dr. Broughton. 176, Madam Chair.
176.
Yes. So you've summarized it at 175, and then you've affirmed it at 176.
That's correct.
So you say here his opinion was based once again on Advocate Chauke's handling of the Boyson matter. He did not deal with the Mduli matter.
I do say that.
Yes. Now, if I could ask you then to go to the opinion of Dr. Broughton, which is at LO 00149.
I'm there.
And if I could ask you to turn to LO 00161.
It is Council LO1, this volume 1,
Yes.
because the number of volumes of this opinion of this document. It is volume 1, all LO
So it's 00149, that's where it starts.
00149. Thank
Yes,
you.
but I've asked the witness to go to 00161.
Yes, thank you.
So if the panel could also have a look at 00161,
Thank you.
particularly from paragraph 41.16 up until 41.21. Can you see there that those paragraphs, firstly, I headed them Mduli prosecution. Can you see that?
I do.
Yes. And can you see there that there is a discussion between 41.18 to 41.21?
I see that.
And then if you turn to page LO 00163
I'm there.
at paragraph 45,
Yes.
can you see there that there is a heading analysis?
I see that.
And then the first subtopic there is the withdrawal of the murder and related charges in the Mduli case.
I see that.
And Dr. Broughton then concludes and says, in light of the findings of the SCA full decision as referred to above, no recommendation is made herein that a Section 12(6)(a) inquiry be instituted against Advocate Chauke relating to his withdrawal decision in the Mdluli case and referring the matter charge to an inquest instead. Can you see that?
I see that.
If you compare that to paragraph 68, which is at 00170.
Yes.
Yeah.
00170.
Madam Chair. Yes. At paragraph 68,
Yes, thank you.
yes, there Dr. Broughton recommends the institution of an inquiry in relation to the Ngcukaitobi case. Is that correct?
He does.
Yes. And then if you go back to 45, there he is expressly clear that he is persuaded by the SCA decision not to make a recommendation in relation to the Mdluli case.
I don't agree with that.
Then if you go to the second opinion,
I beg your pardon. Advocate Batoyi, you do not agree with what?
That he's expressly clear to make, I didn't get a chance to read the full, as Adv Ngcukaitobi was saying it, but he was expressly clear to not, my understanding was to not recommend that the issue of the Mdluli matter be referred to the president. And I disagree with that.
well, I'll come back to that. I just want you to go to the next document. It's in the same, I want you to look at, in the same volume, at LO 00171.
I'm there.
And that's the second opinion on the 21st of April, 2023.
That's correct.
Yes. Now, at LO 00172, paragraph 5, Dr. Broughton says, my legal opinion was moreover based on relevant reported decisions, cited the
Sorry, what paragraph?
paragraph 5,
Page number again?
00172.
Yes,
Yes.
I'm there.
My legal opinion was moreover based on relevant reported decisions cited therein, which decisions pertain to the Boysen and Mdluli matters, correct?
I see that.
Yes. If you then turn the following page at 00173,
I'm there.
at paragraph 7,
Yes.
there he says, in my legal opinion, no recommendation was made as to the institution of an inquiry in terms of Section 12(6)(a) of the NPA Act against Advocate Chauke, relating to his decision to withdraw the matter and related charges in the case involving then Lieutenant General Richard Mdluli, who was the head of crime intelligence within the South African Police Service, and to refer the matter charge to an inquest instead. And then he continues, and that's where you then jumped and you said you didn't disagree. You didn't agree. Then he says, this stance is based on pertinent findings contained in the judgment of the Supreme Court of Appeal in National Director of Public Prosecutions and Others versus Freedom Under Law, as discussed in my legal opinion. Correct?
That's correct.
Then come back to your affidavit at paragraph 173, page 138, where you state that
Sorry,
advocate,
can you repeat that?
page 138, paragraph 173 of volume 3 of bundle file 3.
170.
Yeah. Yes, 173.
Oh, sorry, this one.
Sorry to disturb. Let me take you a step back. Paragraph 7. What was the witness's response to paragraph 7, or you didn't ask for a response?
No, I didn't.
Okay. No,
I
it's fine.
asked the witness to confirm that paragraph 7 says what is contained there.
Okay, so it's fine because I didn't get an answer.
Can you repeat where you are now?
I'm at page 138 of file 3, paragraph 173.
Okay, I'm there.
Now, that is an extract from your affidavit. And I want to just go to that fourth line where you are saying Dr. Broughton did not deal with the Mdluli matter.
Mm-hmm.
Now, that statement is false because we've looked at both opinions. He expressly deals with the Mdluli matter twice.
It's not false in the way that I meant it.
But Advocate Batoy, please, we can all read English. You said the man did not deal with the Mdluli matter. We've established that he dealt with the Mdluli matter.
My response is that it is not false in the way that I meant it.
And then at paragraph 176 of that same page, you again repeat that he did not deal with the Mdluli matter.
That's correct.
Yes. And in your own affidavit before this panel, and I started you there, you repeated that Dr. Broughton did not deal with the Mdluli matter.
That's correct.
Yes. But we know as a fact that Dr. Broughton dealt with the Mdluli matter twice.
It's about the meaning of did not deal with the matter as I intended it in my affidavit. It's pertinent. I mean, one glance at the affidavit shows it's there. I mean, the opinions of Dr. Broughton. It's not like I'm hiding anything, but what I meant by he did not deal with the matter is what's critical in this regard.
Can you explain yourself? I don't understand. It seems to me clear, and I have no doubt that anyone who understands the English language can see that it is clear that in both opinions, Dr. Broughton dealt with the Mdluli matter. Mm-hmm. But your affidavit says he did not deal with the matter. So it's either you are misleading the panel now or you misled the panel in your affidavit.
I didn't mislead at any stage. And the English language is not that simple to interpret. Sometimes it's about context and it's about different understandings of the same word. So I agree. I used the words he did not deal with the Mdluli matter. But I've not yet been asked what I meant by that, but I'm happy to explain, if I may.
In fact, if you go to page 131 of that file 3, now right at the beginning of that page, the chairperson says to you, and this is a discussion about why you went to Advocate Harley. You say, as you say, because the former team of Advocate de Kock, and correct me, whether it is Dr. Broughton or de Kock, one of the two, had not expressed a view in relation to the Mdluli matter. And then you say it is Dr. Broughton who had not expressed a view. And then he says it is Dr. Broughton.
Mm-hmm.
Now, I still want to stick to the fact that you say Dr. Broughton did not deal with the Mdluli matter.
Mm-hmm.
We've looked at the opinions. Do you accept that Dr. Broughton did deal with the Mdluli matter?
I would like to explain what I meant when I said he did not deal with the matter.
I'm not asking you that question. Don't answer your own questions. Do you accept that Dr. Broughton did deal with the Mdluli matter?
He addressed it in his affidavit.
Again, you're not answering my question. You are putting your own statements. Do you accept that Dr. Broughton did deal with the Mdluli matter?
He addressed it in his affidavit.
Yes,
I would like to explain what I meant
No,
by he
Dr.
did not
no,
deal with the matter.
Advocate Patohi, just answer my questions. Don't ask your own questions for yourself. When addressing the matter, that was dealing with the Mdluli matter.
Not in my opinion, not in my view.
Yes. Thank you. I think the facts are clear for anyone to read. Could we then move on to the next topic?
Yes, Counsel. Reference is made to the transcript.
That's correct.
And I don't want to belabor this point, but I'd like to understand what you mean in answering the question by counsel, because we have the transcript here. The very transcript that we are going to have to rely upon when we write the report. And I just need clarity from the answer that you gave when I asked you questions, when you testified in chief, at referring to that page 131 that has been made available to us of the transcript, where you answered the question saying, it is Dr. Broughton had not expressed a view. The words, had not expressed a view. What should we understand that to mean in relation to the Mdluli matter?
Thank you, Chairperson, for giving me an opportunity to explain this. I think it's really important that I do. If we go to Dr. Broughton's affidavit again, where I was referred to earlier on, various parts of it, I have not been. If we go to LO 00163, I mean, firstly, I want to make it clear, as I've said, that I have these affidavits. I have his opinions. It's clear that there's a part of it relating to the Mdluli matter that's included. But when I said he did not deal with the matter, this is what I meant by it. If you look at paragraph...
He did not express a view. That's what you said.
Chairperson, if you look at my understanding of paragraph 45 this is at LO 00163, paragraph 45.
That the analysis part?
That is correct, Chairperson.
Yes.
Chairperson, he says, in light of the findings of the SCA full decision as referred to above, no recommendation is made that a section 12(6) inquiry be instituted. My understanding of that is that he was not making a recommendation not to recommend, but he was making no recommendation. And my understanding that he was not saying do not refer, he was making no recommendation. And that was my understanding when I said he did not deal with it. He made no recommendation regarding this matter.
Yes, but then look further at the paragraph counsel Advocate Ngcukaitobi referred to too. It's not only the analysis part at paragraph 45. Counsel referred to further parts of Dr. Broughton's opinion. For instance, if you look at LO 00170, he makes a conclusion there. And he says, in all the premises, it is respectfully submitted that the NDPP ought to consider making a submission to the President for the institution of an inquiry in terms of Section 12(6)A of the NPA Act against Advocate Chauke pertaining to his involvement with Menace.
That's
he
correct.
Makes a conclusion there.
That's correct.
And it is that paragraph 68 that has to be read in the context of the earlier paragraphs which were referred to you by Advocate Ngcukaitobi, shouldn't we?
Chairperson, my response to that is that my understanding was that he was making no recommendation with regard to the Mdluli matter. He was not saying it should not be referred. Look, if you look at it with paragraph 45, that was my understanding, is that he was making no recommendation.
The point that I'm making is in relation to your earlier evidence at page 131, the transcript, where you said Dr. Broughton's expressed no view.
That was my recollection, Chairperson, is that because my understanding was that he made no recommendation, I took that as not expressing a view. He made no recommendation. That was my understanding and how I interpreted it.
Yes, thank you.
Advocate Batohi, let's go back to paragraph 45.
Paragraph?
45, LO1, LO00163.
I'm there.
Do you mind reading it aloud into the record?
Sure. In light of the findings in the SCA full decision as referred to above, no recommendation is made herein that is section 12(6)A inquiry be instituted against Advocate Chauke relating to his withdrawal decision in the Mdluli case and referring the murder charge to an inquest instead.
There is no full stop after no recommendation.
That's correct.
It proceeds and said, no recommendation is made herein that a section 12(6)A inquiry be instituted.
That is correct.
So that is Dr. Broughton expressing his opinion that no recommendation should be made or no referral should be made to refer Advocate Chauke in relation to the Mdluli matter. If you read that whole paragraph, because it's just one sentence.
That is not the way I read it.
You read it up to no recommendation and stopped there.
No, I didn't.
Okay. So what do you make about the next few words? Is made herein that a section 12(6)A inquiry be instituted against Advocate Chauke relating to his withdrawal decision?
As I mentioned, my understanding of this is that he made no recommendation. It's not that he recommended that the matter not be referred.
I think I'll accept it. It's a matter of semantics. Thank you.
Thank you.
Yes, thank you, Advocate Batohi. The rest will be a matter for argument.
Thank you,
You
Chairperson.
may proceed, Counsel.
Thank you. Advocate Batohi, I will argue that you've lied in your evidence when you claimed that Dr. Broughton expressed no view. Dr. Broughton expressed a view. You've also lied in your evidence when you said Dr. Broughton did not deal with the Mdluli matter. He dealt with it extensively. Could I move on to the...
No, I'd like to respond to that, please.
Yes, respond.
I was just writing it down so I get it right when I respond. Firstly, I've got no reason to lie in this matter. No doubt you'd probably find an argument that I do have a reason. But let me say that I did not lie when I tendered my evidence. My understanding of it, the way, in light of Dr. Broughton's the part that he deals with the Mdluli matter, my understanding of it was he was making no recommendation in that matter. And that was my understanding. I'm not lying about that. And when I said in my affidavit, he did not deal with this matter, why would I lie about it when his supplementary affidavit, it's there for everyone to see that it is he addresses it in his affidavit. So why would I lie about that when a glance at his opinion would see that there is a portion that addresses the Mdluli matter? So it's not a lie. It is my understanding about it. And the comment by counsel that it's dealt with extensively in his opinion is, in my view, not the correct one, because if you look at his entire opinion and annexures, the Mdluli matter is dealt with, I would say, I'm guessing 1% of that opinion would be too much, but it's just in a few pages, and we have 2 lever arch files. So I want to really emphasize that I am not lying about this. I've got no reason to lie about it. That was my understanding.
To show your lie, when you answered the chairperson, until the cross-examination, those paragraphs pertinently addressing the Mdluli matter were never brought to the attention of the panel by yourself.
Can you repeat that?
I'm saying, to show your lies to this panel, those paragraphs were never brought to the attention of the panel by yourself until the cross-examination.
In my view, there's a lot in this document that I have not, otherwise I should have been given a few days to read out Dr. Broughton's opinion, all of them, the first one, the supplementary one, and to go through all of his evidence. I have just dealt with the key aspects of his evidence. But what is before this inquiry is all the reports, all the documents, and this is in fact what the inquiry has to look into, is whether all of that evidence supports that Advocate Chauke either conducted misconduct or is not fit to hold office. But it's not just those parts that I have referred to. It is the totality of all of the evidence.
Yes. Could I move on to the next topic? When we left on Monday, we had left a question around the origins of the terms of reference. You remember that?
I don't remember specifically, but I know we did deal with it.
Don't you remember that the chairperson had asked, how did the president get to those terms of reference? Were they recommended by you or were they not recommended by you? And you denied that you had recommended them. In fact, you said that the terms of reference that were concluded were different to the terms of reference that you submitted.
I did say they're different.
Yes. If I could ask you to go to file 3 again, starting at page 163.
Is that your file?
Yes, file 3, 163.
I'm there.
Now, this is a letter written by Advocate Ngcukaitobi, who is part of the NPA team. One of the annexures that are submitted is Annexure L. Now, Annexure L is a draft letter to be signed by the president. And it's itself not signed. And I want to show you, it's at page, I must find it now. It's at page 181. Yes, it goes from page 181 to 183.
I see that.
Who gave the president this draft letter?
I did. I think it was the one that was attached to the bundle that was sent to the minister.
Yes, you gave the president this draft letter.
That's correct.
Now, if you then go to,
I beg your pardon, Council. Annexure L, is it that letter at 181, at page 181?
yes, Madam Chair, it is. Yes.
Should we then mark it in your bundle? That will be.
Yeah. Yes, Madam Chair, we've just put this as a cross-examination bundle.
It is. This is the exhibit document. It forms part of the exhibit document. This list, and that's just SB 10 to. You see, in that page 163, I'm trying to get my thinking right. Page 163, those annexures, including 12, Annexure L, draft letter to be sent to Advocate Ngcukaitobi by the President. These documents form part of the list of exhibits that were handed to us last week, early this week.
Madam Chair, I need to just confirm with my junior. I'm not sure what the answer is. My junior tells me that, no, this is the first time we've been given this particular annexure. It's not part of the SB 10.
This is the letter that we spoke about that was handed from the bar. Which letter is this? Page 181.
Madam Chair, what had happened is that Advocate Batohi wrote to the Minister of Justice asking for the establishment of this inquiry, attaching various annexures. One of the annexures that were attached is Annexure L.
Annexure L is the presidential response to Advocate Batohi's formal letter.
No, Madam Chair, it is a draft for the president to append his signature.
Oh, thank you.
Yes.
Thank you.
Yes. Now,
Yes, just a minute.
yes.
Just a minute. Just want to understand because we have bundles and bundles of documents here. And these are the documents which had been requested.
Yes. They were
Yes,
requested in the cross-examination.
Yes, thank you. Now I understand. Thank you.
Yes. Now, Advocate Batohi, just to go back to the answer you gave, you accept that you are the author of this document.
Well, my office would have prepared it, and I attached it to the memo to the minister.
Well, when I say you, I mean you and your office. I'm not saying you were typing it, if that is how I came across. Do you accept that your office?
It came from my office, that's correct.
Yes. Now, if you then go to page 182.
I'm there.
Item A. Your office said to the president that the president must institute an inquiry into whether or not Mr. Ngcukaitobi, in the Boysen matter, supported a decision to prosecute, notwithstanding that there was no evidence justifying the decision. Correct?
I see that.
Yes. Now, and then the balance there refers to the indictment in the case, which does not appear in the final terms of reference.
Sorry,
Correct?
can you repeat that?
After the word KwaZulu-Natal, can you see that?
I do see that.
It talks about sign the indictment, correct?
That's correct.
That was your draft, but in the final terms of reference, those words have been taken out, correct?
That's correct.
Yes. The rest of those words are exactly as they were in your original terms of reference, correct?
That is correct.
You look at B. B has been taken exactly as it is and put in the final terms of reference.
It appears so.
Yes. The same with C has been taken exactly as it is and put in the terms of reference.
That appears so.
Yes. The same with D. It's a cut and paste.
I haven't checked, but I'll take your word for it.
Yes, well, I have checked. That's why I'm able to say the words sign and indictment appear in the draft. They don't appear in the final version.
I accept that.
The same with E. It is a cut and paste.
I'll take your word for it.
Yes. And
What do you mean? It is important for me to understand what you mean when you say you take council's word for it.
Chairperson, if I have to agree, then I'll need the other document next to me, and I need to then check word for word. In the interest of time, all I say is I don't disagree with council. I accept what he's saying.
And I should accept that to mean you agree with council. It is important for me to understand what you mean when you say you take council's word for it.
Chairperson, then I need to look at the other document to check every word to make sure it's correct. I'm saying is I have no reason to doubt council.
Therefore, you agree.
I don't doubt him, Chairperson.
I beg your pardon?
I do not doubt him.
Therefore, because you don't doubt the veracity of what he says, you agree with him.
If that's a conclusion, Chairperson, then so be it. But I
beg your
don't doubt him.
pardon?
If that's a conclusion, then it's fine. But I have no reason to doubt him.
Perhaps, council, we must go to the terms of reference.
Chairperson, may I just clarify one thing? That when I said that the terms of reference were different, look, I've not looked at this letter. Again, I have to go to the fact that this affidavit was drafted at very, very short notice. We attached documents that we'd sent in the interest of transparency so that Advocate Ngcukaitobi's team has all of the necessary information. The terms of reference, when I said were different, I was not referring to this letter to the president. My understanding is that there's another draft terms of reference that I have looked at. That is my understanding when I said that they were different, because there's another draft that we prepared, and I looked at that draft and the terms of reference, and that is a lot more different. But it appears what the president's office did is they have taken from this letter and added to the terms of reference. But we have another draft, which when we looked at with the terms of reference is different. My understanding was that we had submitted that draft as well to the president's office.
It is a very long answer. I just wanted to ascertain whether I understand your answer to Advocate Ngcukaitobi. It may well be that he's going to cover those aspects that you are raising, but I just want to understand when you say you don't doubt the correctness of what he puts to you, whether you are saying you agree or not. That's just as simple as that. Maybe to assist Advocate Ngcukaitobi, you can take the terms of reference and contrast them with the contents of the letter and take Advocate Ngcukaitobi to each and every part of that, so that when she answers correctly, understanding what has been put to her. It may take a bit of time, but it is important to get the correct answers from her in relation to the questions that you are putting to her.
Yes, Madam Chair, thank you. Perhaps then let's go to the beginning. If you could just take a copy of your terms of reference and then turn to page 4 of the terms of reference. And then let's start at 3.1.1.1. Yes. So if you exclude the preamble, because the President has included his own preamble, but you look at where it says supported a decision to prosecute the accused, notwithstanding the fact that there was no evidence justifying the decision. And you sought improperly to have the then acting DPP of KwaZulu-Natal sign the indictment in the case without providing him with the case dockets and or prosecution memorandum detailing the alleged evidence implicating the accused on which the decision to indict had to be made. You see there that the only words that are not included are the words "the indictment" in the case that are not included in the final draft. The rest of it is identical.
In other words, when you take the gazetted terms of reference, and I suppose I'm correct, Advocate Ngcukaitobi, and you contrast them, or at least let's look at 3.1.1.1 of the gazetted terms of reference, and you contrast that with page 182A of what has been referred to you. Do you agree with Council's question?
Chairperson, I'm looking at the two paragraphs, and what I see in the terms of reference, what's also not in the terms of reference, I'm not sure whether Council has covered this, it says without providing him with the case dockets and or prosecution memorandum. And in the terms of reference, it says to sign the case dockets and or prosecution memorandum.
Yes, we agree on that. That's the part I was reading, saying that's excluded in the final terms of reference. It starts with sign the indictment without providing.
In the terms of reference, it says sign the case dockets.
No, I'm saying in your draft, it says sign the indictment.
That's correct.
So that's all excluded.
That is correct.
Now, you remember where this became an issue is the reference to the word case dockets, which you said does not exist. And then I asked, how can it not exist? Because you drafted these terms of reference.
Can you repeat that?
I'm saying, you remember where this discussion started?
Mm-hmm.
It was when I referred you to the words in the final terms of reference, case dockets.
Mm-hmm.
And you said there are no case dockets. And I asked, how can there be no case dockets? Because the charge sheet refers to case dockets. And then you said, well, I don't know about this charge sheet. I didn't prepare it. But what I want to refer you is
But can I respond to that? Because that's not what I said. And when the questions are too long, I'm not able to respond to things, and then it gets confusing towards the end.
Answer it.
So firstly, I didn't say there were no case dockets. I said there was no, to my knowledge, there was no racketeering case dockets.
Yes.
That was my answer. I did not say there were no case dockets.
I understand.
Because we know for a fact that there were 23 murder dockets.
No, we are talking about the racketeering case docket.
So I think that should be made clear. I did say there was no racketeering case docket, to my understanding.
Yes, well, this is the point I'm making to you. You said the entire charge, 3.1.1, is about racketeering.
Can you repeat that?
You said the entire charge in relation to 3.1.1 is about racketeering. That's the only case docket we are talking about.
So when I said it relates, I didn't say the entire charge. You know, we must look at the record and see what words I use, because they being put to me as me saying the entire charge. What I meant is that the charge that we were referring to was racketeering.
Yes.
That's correct.
But that's the only charge that you have an issue with under 3.1.1.1 until 3.1.1.5.
That is correct. We're dealing with the
Yes.
racketeering.
Yes. Now, we come back then to the reference to case dockets comes from your own draft at A.
That's correct.
Yes. Can we then move on to
Can I explain that before we move on?
Yes.
I would like to explain it because we leave things hanging and then there's no explanation for it. Chairperson, the reference to the case dockets there were 23 murder case dockets. And that is the reference to what this is saying is that he was not provided with those case dockets. Now, those case dockets could potentially or would potentially be the basis for predicate offenses in any racketeering charge. So it would have been important for a DPP to have all of that if he is required to sign an indictment for a racketeering charge. So that was the context or what I would have said at the time with regard to case dockets.
Yes. Could I then move on to item B? Now, if you remove the first words in the Boyce Ngcukaitobi matter, you start with recommended. Now, I didn't see any difference of substance there. You can compare it yourself and
I'll
tell
do
me.
that now. That's correct. It's the same.
Yes. If you look at C, if you compare that with 3.1.1.3, again, just remove the words in relation to the Boyce matter, starts with sought to defend. Again, I didn't see anything different there.
That's correct. It's the same.
If you look at D, let's do the same exercise and compare it with 3.1.1.4.
That's correct. It is the same.
Then the last of the racketeering charges is E compared to 3.1.1.5, starting with the words attempted. Again, I saw nothing different there of any substance.
That's correct.
Yes. Now, the matter of Lieutenant General Mdluli is worded slightly differently. The 3.1.2 starts with the words, the failure to continue with the charges against Lieutenant General Richard Mdluli for his involvement in the murder of Mr. Tefo Abel Ramokhibe. Those words do not appear in your draft. Is that correct?
That's correct.
Yes. But the critical part starts with caused, and it comes directly from your own paragraph F. Compare those words caused, starting with where it says Advocate Chauke caused at 3.1.2, and at F, look at after the Mdluli matter caused, and tell me if there is any difference.
It's the same.
Yes. Now, this is the whole point why we asked for the draft that you sent to the president. What we can now say is that these terms of reference are virtually identical to what you gave the president, except for item A, which we discussed. And yet you've given evidence that seeks to distance yourself from your own terms of reference. Can you explain yourself?
Yes, I'm not seeking to distance myself from my own terms of reference. When I said that these final terms of reference were different to the terms of reference, the draft that we had submitted, Chairperson, I was not comparing it with this. This is not a terms of reference. The document that Council is referring to is a draft letter to the President. And I accept that we've gone through this exercise. I was referring to a draft terms of reference, which I understood that we sent to the President's office separately from this letter. Now, I have seen a draft of that document, but my office was trying to find the precise one that was sent to the President. And that is the document that I was referring to when I said that it was different from these terms of reference. I was not comparing this final terms of reference with the draft letter to the President. In fact, I've not even, but for when this letter went, I've not even looked at this letter in preparation for this inquiry, because I've just had no time to look at all of these documents. But to be clear, when I said it was different, I was not referring to the draft letter of the President. I was referring to a draft terms of reference, which we also submitted, is my understanding, to the Minister.
So the problem, Advocate Batoy, even this document we've now gone through painstakingly was never disclosed by you. It came up in the cross-examination.
So, Chairperson, again, I want to be very clear. There's nothing we want to hide in this matter. These documents are all referred to in the document that was sent to the Minister. They all attach as annexures to my SB 10. They are annexures A to M, which are referred to, well, it should be referred to. Let me just get to SB 10 before I start saying things that are not absolutely accurate, because I do want to be accurate in the circumstances, as accurate as I can be. I'm looking at SB 10. It goes to annexure F, J, K. What's the last one? J. K is on 175. Annexure K, L, and M. So SB 10 refers by name to every one of these documents that was submitted in the bundle. We are not withholding anything, Chairperson. It was just that my affidavit would have been extremely long if we attached everything to my affidavit. So what we did is we referred to them and didn't attach them. But it's not withholding evidence, Chairperson. It's all in my affidavit.
You see, the problem even with that answer is that if you are going to give evidence to this panel that the President has given you terms of reference that are different to what you submitted, you have an obligation to disclose to the panel that you also gave them Annexure L.
It's in my affidavit that I gave them Annexure L, so I'm not withholding it. It's SB 10, refers to Annexure L.
Just one, concern. And the concern that I have raised even in the past about non-provision of documents in advance. This SB 10 that you are now talking about.
Pardon me?
I say this SB 10 that you are now talking about is part of the documents that came late to the inquiry.
No, it's
the annexures I'm still talking. The annexures, I think, as lawyers generally, and even as human beings, we understand that it is very important that if you give me a document that makes reference to annexures, those annexures must be part of the document. The reason that you deem it fit to see it as an annexure to the document, it means it's an important document. So here we are today, we get these documents that we are told are just coming to surface to the inquiry for the first time today. Thank you. Is it soft? Oh, I'm told for a change, my voice is very soft. Okay.
I'm struggling as well. That's why I've been asking.
Oh, okay. Maybe there's something wrong with me. Sorry about that. I beg your pardon. Ordinarily, I'm told I scream. So I try to be a ladylike and talk softly. It doesn't help. Okay. You understand my concern?
I do.
Okay. Thank you.
Can I respond?
Yes, you may.
Thank you. So I did tell my team, we did say that we must look at my affidavit and make sure that all the annexures are uploaded. And I would have expected that all of these documents that are annexures to my annexures would have also been uploaded. So to the extent that they have not been, and I need to confirm with the team, I will apologize for that. But that was an exercise that they were meant to go through meticulously to make sure that every annexure to an annexure is uploaded. So I will check with them and see what the position is. And I would have thought that that would have been done by now.
Yeah, I don't want to belabor the point. I've just been tempted to reiterate this concern now. Thank you.
No, thank you, Chairperson.
Yes. Advocate Batoya, I'm sorry I'm not done on this point.
It's fine.
Because your claim that Annexure L was attached to SB 10 is a lie. If you go to SB 10 275, page 275, paragraph 31, and that's your letter of the 18th of August 2023. It says, it is further recommended that Advocate Ngcukaitobi be afforded an opportunity by the President to advance reasons as to why he should not be suspended and a fitness inquiry be instituted against him. A draft letter is attached here too as Annexure L. Annexure L itself was never there.
I think it is important for the record to make mention of the fact that SB 10 forms part of Advocate Batoi's affidavit.
Yes, indeed. Thank you, Madam Chair. So if you, Annexure SB 10, which is
It is SB 10 266.
yes, SB 10 266, yes, that's where the document starts. And the specific paragraph I'm referring to is paragraph 31, which is at SB 10 275. What I'm asking you, Advocate Batoy, is that your statement that Annexure L was included in SB 10 is a lie, because Annexure L was never attached to SB 10.
Before Advocate Batoy answers, which paragraph did you refer to?
Paragraph 31, Madam Chair, at page SB 10 275.
Chairperson, can Council please repeat that? Because I want to be clear about what it is it's alleged that I'm lying about.
When you say, I said to you, you failed to disclose Annexure L. Then you said, I did not fail. It is part of SB 10. And I've now gone back to SB 10, particularly at paragraph 31.
Mm-hmm.
What is stated there is that it is further recommended that Advocate Chauke be afforded an opportunity by the President to advance reasons as to why he should not be suspended and a fitness inquiry be instituted against him. A draft letter attached hereto as Annexure L. Annexure L was never attached to SB 10.
That is correct. Well, let me rephrase that before I answer that quickly. SB 10 is a letter to the President. Let me get that right. Is a memo to the Minister. And those annexures that you're referring to are annexures to the memorandum to the Minister. These would have been attached to the memorandum to the Minister, but they were not attached to my affidavit. So when the attachments to my affidavits were put together, the memorandum only was attached, not the annexures. But my point was that if one reads the memo itself, it refers to all of these annexures and gives a description of them. Let me just make sure that I am clear about that, because I am, just a moment, Chairperson, if you give me a moment. I just want to make sure that I am, I'm going to look at Annexure L now so that I am clear. Annexure L is in the bundle provided by Advocate Chauke's team. If I could just be helped with the page number, it will be useful.
I beg your pardon.
What page?
Let me correct that. Annexure L
Mhm.
forms part of the documents that were referred to or put together by your junior counsel, Advocate Ngcukaitobi,
That's correct.
in a document that was emailed to Katleho Aubrey and to yourself, among other people.
That's correct,
who
Chairperson.
are mentioned in that email. So it is not correct that it's provided by the team of Advocate Chauke. It was provided by your office, if I may put it that way. And that consists of the list of those documents at page 163.
Chairperson, I am not incorrect when I say it was provided by them. I meant it was provided in this big file. This is the file that I received from them. So that is what I meant. But you are correct indeed that this is something that came from my office and was sent to them by email.
And Advocate Ngcukaitobi copied you that email.
Yes, that's correct.
So you had the document.
Yes, I'm not disputing that.
I'm just correcting the fact that it was provided by Advocate Chauke's team.
Chairperson, I'm saying I did not. What I meant when I said that is that this entire bundle in this black file has been given to me by Advocate Chauke's team. And it's in this bundle. That's all I meant. But of course, it comes from my office.
The source.
Yes,
is your
absolutely.
office.
But they handed me this bundle. That's what I meant when I said they gave it to me.
It is very important to get it right, because we will get confused when we write the report.
Certainly, Chairperson, I will be mindful of that. So let me look at Annexure K. I'm going to try to, if anyone can guide me to the page, it will be quicker so that I can read this document.
Sorry, Advocate Ngcukaitobi, I interrupted.
Yes.
You had referred Advocate Batoi to
Paragraph 31, which is,
paragraph 31.
yes, simply to ask her, and I think she has done that, to confirm that that Annexure L was not part of SB 10.
Let me correct that, Chairperson. It was not attached to SB 10 in my affidavit, but it was certainly part of the memorandum that was submitted to the minister when it was submitted. But as I've been painfully trying to explain, we did not add all the annexures when we did my affidavit. and they have been now supplied to counsel, to Advocate Chauke's team.
Advocate Batoyi, can I ask you, on your main defense on this issue, which is that this was a draft letter that you prepared for the president to sign when suspending Advocate Chauke, and you did not expect that this would be the terms of reference. Now, it is a bit of a puzzling expectation on your part. Why did you not expect them to be part of the terms of reference when you've given them to the president?
My understanding is that we submitted a draft, but I could be mistaken about that. But this was a letter to the president, and I didn't know what in fact, it was a draft. The president is at liberty to change that letter as he deems fit. We did not expect that this will find its way into the terms of reference. It was explaining to the president, in summary, what issues we had with Advocate Chauke's conduct.
Yes, there was another document, but we have not found the source of it. If you go to page 177 of file 3.
I'm sorry. This draft letter, as you have just mentioned, sought to convey to the president what issues you had with Advocate Chauke. As you have just mentioned, I just want to check.
Can we look at the draft letter again,
No.
Chairperson?
I'm referring to your answer that you have just given now.
Yes, I answered it, but when I realize it's being scrutinized to the level it is, I'd like to look at the letter.
No, Counsel. I'm asking you. You responded just maybe a minute ago that the draft letter sought to convey to the president what issues you had with Advocate Chauke. That was your response.
Chairperson.
Because I want to ask you a question on that statement.
Well, I would like to look at the letter first.
No. Did you answer to Counsel his last question when I interrupted him, that you answered your draft letter to the president was to convey the issues you had with Advocate Chauke?
Chairperson, that was loosely put. That is why I'm asking that I refer to the letter. There may have been other things there that I added, and I think in fairness, I should be allowed to look at the letter and then say exactly. I loosely put it. I didn't refer to it because we've been through some of it and we've compared it with the terms of reference, and it relates certainly to some of the conduct that we had an issue with, but there are other things in the letter as well.
No, I'm not talking about the contents of the letter. I'm asking you a question based on your answer to Advocate Ngcukaitobi, that your draft to the president was to convey the issues that you had with Advocate Chauke. That was your answer, correct?
Chairperson, we sent a whole bundle of documents to the president.
No, Counsel. And I'm going to ask you again for the last time. When you responded to Advocate Ngcukaitobi a short while ago, you said your draft letter to the president sought to convey to him the issues that you had with Advocate Chauke. The words to convey the issues you had with Advocate Chauke. Is that what you said?
That's what I said, loosely.
Yes, thank you.
Yes. In fact, on this topic, the suspension letter of Advocate Chauke is identical to the draft that you prepared. I don't need to go through it, but we can accept that.
Sure.
Yes. Now, I wanted to just come back to trying to understand what is the substance of your answer. There is a document headed the Presidency Draft Terms of Reference at page 177 of file 3.
Page is that?
177, Madam Chair.
177.
Yes. Now,
And what is the question with regard to that?
yes, thank you. If you could go to page 179. What this document does is to identify the issues to be decided.
What is this? I'm sorry.
Yes.
For the purpose of the record, what is this document
Well,
at page 177?
I'm very happy, Madam Chair, you've asked that question because it's one of the documents we received from Advocate Ngcukaitobi. And I was going to ask the witness to explain what is the status of this document.
At 177.
At 177, yes.
Thank you.
Yes. Advocate Batoy, if we could just go to 179. This document purports to identify the issues to be determined by the inquiry. At Roman figure 1 and Roman figure 2, in broad and generic terms, but does not identify any terms of reference in the same detailed sense that the gazetted terms of reference do. Now, who prepared this document at page 177?
So this is the draft terms of reference that I was referring to earlier, Chairperson. It was prepared by my office.
Was this a first draft, a final draft?
I can't recall. I assume it would have been the final draft.
And what happened to it? You gave it to the minister?
Well, I thought it would have been sent to the minister because that's why we drafted it. But I'm not sure.
Yes. In any event, the point I'm really trying to understand here is it's only at page 179 where there is an identification of the issues to be decided. But there are no actual terms of reference in that document at all.
The heading of the document is draft terms of reference.
Of course.
And in fact, there's nothing wrong with having broad terms of reference.
Now, what I'm asking you is there are no terms of reference in the document. There is an identification of the issues to be decided at page 179.
This is a draft terms of reference document. We can quibble about semantics, but this is the draft terms of reference. And at page 179, as you say, the issues are broadly defined.
Yes. The only document that specifies the complaints against Mr. Chauke to the level of the terms of reference is what we were looking at page 181.
That's the letter to the president and not
Indeed.
the draft terms of reference. That
Indeed,
we draft.
yes.
That's correct.
And that's what ultimately makes it as terms of reference by the president.
That was
Page 181.
That's the president's decision.
Yes. Thank you. Now, in relation to that final document and your own draft, you've never identified the issue of Mr. Chauke acting in excess of his authority as part and parcel of that letter at page 181.
Chairperson, I'll have to look at this carefully. Chairperson, the terms of reference have got to be drafted, have got to be read in its entirety. If we look at page 178, it refers to, well, before that, Chairperson, if I may, page 177 refers to the relevant sections in the Constitution. I won't go through all of them. It refers to sections in the NPA Act. And then at page 178, it states in the third paragraph, and whereas Section 24(1) of the NPA provides that a DPP has, in respect of the area for which he or she has been appointed, the power to do various things. It just quotes the section again. If we go to page 179,
Just remember, you are trying to find a section that says Advocate Chauke acted in excess of his authority by getting involved in a KZN matter.
I'm answering the question.
Well, okay. Well, show us then the passage.
I'm answering the question, Council. Sorry, Chairperson. Chairperson, at page 179, it states the issues to be determined by the inquiry are set out below. And then if we go to Roman 2, it says, insofar as it relates directly or indirectly to the conduct of Advocate Chauke and his fitness and propriety to hold office. Oh, sorry, that's not what I should be reading. Roman 2, whether in fulfilling his responsibilities as Director of Public Prosecutions, first bullet, Advocate Chauke complied with the Constitution, the National Prosecuting Authority Act, and any other relevant laws in his position as a senior leader in the National Prosecuting Authority. Chairperson, if we also look at the bullet on page 180, the second round bullet, and this may not be the only ones. Advocate Chauke exercised his powers and performed his duties. Well, before that, Chairperson, the first bullet, Advocate Chauke duly respected court processes and proceedings before the courts as required by applicable prescripts and as a senior member of the NPA. And the bullet, next one, Advocate Chauke exercised his powers and performed his duties and functions in accordance with the prosecution policy directives as determined under Section 21 of the NPA Act. Chairperson, certainly it does not specifically state, those words are not used here, that he acted outside his jurisdiction, but everything that I've read indicates that very aspect. It requires Advocate Chauke to exercise powers as the DPP within his area of jurisdiction. And all of these paragraphs that I have mentioned must be read with the conduct when Advocate Chauke exercised powers that were not granted to him by the Constitution or the NPA Act, in that he exercised them outside of his jurisdiction.
See, Advocate Batoy, you've now summarized a new term of reference, which would have been one sentence. Why did you not include it in the draft?
Chairperson, I don't know. I can't answer that. So if it's a mistake, it doesn't mean this inquiry can't. The purpose of this inquiry is to inquire, in my humble view, into the conduct of Advocate Chauke. And certainly it cannot be if there was an oversight or if it was drafted in a way differently to what council thinks it should have been, that it should in any way constrain this inquiry.
So you see this inquiry as also fixing your mistakes and your oversight and your sloppiness in drafting.
That's your comment, and I will not respond to that.
But you are the one who said that merely because there was a mistake merely because there was an oversight, should not constrain the inquiry. So it's completely justified for me to put it back to you that you see the role of this inquiry as fixing your mistakes, fixing your oversights, and fixing your sloppiness in drafting.
Counsel, you think you justified. I don't. We can agree to disagree on that.
Are you going to answer the question or not?
I disagree with that.
So you don't see this as the job of this inquiry to fix your mistakes and fix your sloppiness in drafting?
I do not see it as the job of this inquiry to fix my mistakes or my sloppiness.
Yes. Now, when you look at the draft letter from page 181,
I should add that that is your...
Pardon, Counsel. The Counsel asked you a question, you answered, and he's now asking you another question, then you answer whilst he's asking you. I think it is important, Advocate Ngcukaitobi, to accord one another the respect and just to observe the decorum.
I have absolute respect for Advocate Ngcukaitobi, Chairperson.
Well, you can say it, but you don't show it.
I apologize, Advocate Ngcukaitobi.
look, there's no need to, anyway, thank you for the apology. Let me not poison the water already.
It's 11:15. You may pause where the apology is 11:15. You just pause where the apology is given, and you will continue when we reconvene after the tea adjournment.
Thank you, Madam Chair.
Remember the point where you stopped, and then we'll take it from there. We'll adjourn for tea until 25 to 12.